Okay, guys, so INEC has started confessing on what the masses have been talking about. They have come out to make a statement which is going to indict them even more. We were not aware of Tinubu's drug-related forfeiture of $460,000 before 2023 election, INEC. So the truth is, first of all, the fact has been established that he forfeited $460,000 for drug-related issues. They said they did not know before the 2023 elections. The Independent National Electoral Commission (INEC) has told the Presidential Election Petitions Court sitting in Abuja that it was unaware of the 20-year-old United States District Court judgment which ordered President Bola Tinubu to forfeit 460,000 US dollars suspected to be proceeds of narcotics trade. According to INEC, the case was not brought before to its attention prior to the 2023 presidential election. This was contained in its final written address filed by its late counsel A.B. Mahmood SAN against the petition filed by the presidential candidate of the Labour Party, Mr. Peter Obi. In one of the grounds of Obi's petition, which seeks the removal of President Tinubu, his legal team, led by Dr. Levi Uzoku SAN, stated that Tinubu was at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of 460,000 US dollars for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court. Okay, they had argued that the presidential election petitioned court to disqualify Tinubu on that ground, among other prayers. But in its final written address obtained by the Whistler, INEC's late counsel Mahmood maintained that the said forfeiture order was not brought to the attention of the commission, especially by the petitioners prior to the election. On the alleged imposition of fine on the second respondent, that is Tinubu, by the United States, the case of the first respondent, that is INEC, is simply that same was not brought to its attention. However, he told the Presidential Election Petition Court that the 1999 Constitution provides that the fine that disqualifies one from running for president must be associated with a court sentence. However, Section 137 of the Constitution, which provides for the sentence of fine as a disqualifying factor in respect of presidential candidate, states as follows. 1. A person shall not be disqualified for election to the office of president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud, or for by any offense imposed on him by any court or tribunal, or substituted by a competent court of authority for any other sentence imposed on him by such a court or tribunal. A.B. Mahmood SAN argued that in the 1999 Constitution, the prescription of fine as a disqualifying factor for a presidential candidate is hinged on a sentence. He contended that in line with testimonies of a number of witnesses at the proceedings, the US case was a civil forfeiture proceedings and there was no charge or conviction. Thus, the petitioners failed to prove this allegation, and we urge the court to so hold. We urge the court to resolve this issue in favor of the first respondent and hold that the second and third respondents were qualified. The learned Silk urged the Presidential Election Petition Court to also agree with the submissions of the lawyers representing Tinubu, Kashim Shettima, and the APC regarding the matter. They continued that the US judgment was not a criminal conviction.